on the data requests and how those are going to be processed. We'll then go into subgroup topics and goals. We've had a number of questions on how effectiveness of the predatory offender registry is going to be a part of the subgroups and those topics and discussions. So there will be a brief chat about that as well. And then at the end, we will be opening up to public comment. So I have some set times on these items. I will be trying to keep folks to those times, not for a lack of wanting to have discussion, but because we know that the subgroups are going to be deeper diving into each one of these topics. And we don't want to take up too much of the time in the central group when each one of the subgroups will be addressing these issues independently. Just a couple of friendly reminders before we get started. Folks, please be emailing Mark and I as to your subgroup preferences. We've received the majority of requests for those, but we would ask that everybody provide a preference. Otherwise, we will just plan on inviting you to all of them, and you can pick and choose how you want to participate with those. So with that, let's get started. Patty, you are up if you are comfortable with starting. Oh. Mark, can you unmute Patty, Kendra? Oh, there you are.
There you go. It wasn't allowing me to speak. My husband would love that option. Sorry. Thank you. I really wanted to spend a couple minutes to just talk about where this all came from. When Jacob was kidnapped, we learned probably the first day the #1 motive for kidnapping is for sexual purposes, which was out of my realm of consciousness. I knew nothing about sexual crimes against children. But we were also told it's usually not a stranger. It's usually somebody who knows a family or knows a child at least casually. So this is just the perspective that we knew or had lived through back in 1989. I remember asking the investigators what do you need? What would have helped, at the beginning, what would have helped you find Jacob sooner? And they told me two things. Neil Nettemeyer was with Hennepin County. He said, a central repository of information. We did not have that at the time, Minnesota. You'd have to go county by county, city by city to know who'd done these crimes before. And sex offender registration, knowing specifically on those crimes. There were only 6 states that had it at that time. And I know we had somebody from Washington State come and testify before the legislature in the effectiveness of what they had built. And I think they've been very creative along the way, as has Minnesota and many of the changes that have happened. You have to have perspective of where we were at that time. I know that we worked with a man who was helping to fundraise to make sure every law enforcement agency had a fax machine. So just think about the development of technology. We did not have the internet connecting everybody to everybody, and social media was not a factor. That's changed everything. Washington State also conducted a research project that was released in 1997. So we were learning along the way. And one of the things that I would like Minnesota to have is a strategic plan. I mean, build what would be the best case management of how do we manage sex offenders, instead of we often have knee-jerk legislation when another horrific crime or kidnapping happens, and people want to look tough and they want to have a response. And if we're not strategic about it, a lot of things can happen that have unintended side effects. We knew at the time that this report from Washington State said that slightly more than half of the people who had a prior conviction were committing it against children. So they were looking at anybody who had any kind of prior record of an arrest. In nearly 60% of the cases, 2 hours had passed before people even reported the child as being missing. And then yet 76% of the kids who were found murdered were killed within the first 3 hours. So what we were looking for was that really small window of trying to find this child alive. And for that, I think it's an incredible tool for law enforcement to know who's in the area, who's done this before. We didn't have any of that information. The immediacy of the calling the police is something also that needs to be out to the public. We were contacted right away about doing some legislation, and like I said, we didn't know anything. So it's really important to have these committees studying it. We worked hard and passed in 1991. You'll get a whole history in the PowerPoint. And then we went on, Dave Durenberger offered to help take our law and make it federal, which mattered a lot because of the travel aspect. And that was passed as part of the 94 crime bill. I know that sex offender registration worked in Drew Chaudine's killing. Kidnapping, the murderer was, the man who took her was identified within, I think, an hour. It was right away that they located him. So I know it can be a useful tool. Just before our federal law passed was when Megan Kenka was kidnapped, and they added the additional sentence that law enforcement may notify communities upon the release of a violent offender. And that pretty much changed everything. We were asked, to have it be a sentence in the Jacob law, which we had worked on for 5 years now at this point. And I was very concerned about how that would change everything. And I think those concerns are still legitimate, and we have to look at what's working. If we look at the intellectual side, not the emotional side of this, it's like, how can we make these people turn their lives around and succeed? Because that would mean no more victims. That's the goal. I think that's the goal of every parent in the state, is that this person would never do it again. We've had many amendments. The one that concerns me the most is regarding putting juveniles anywhere near a sex offender registry. Who I was before Jacob's kidnapping, is my first job teaching was for high school dropouts. I worked many years in programs where kids had failed, or they got sent to the school through the criminal justice system as an alternative. You either go to this school and get your GED, and these were training to be merchant marines, so they're getting a job and in an education. And to me, that is a brilliant solution. It gives these kids an opportunity to overcome a mistake or a bad decision and become successful. And putting them on a registry, there's just so many negative aspects for it. So I will fight really tooth and nail to not have kids on the registry at all. I met Ricky, who was 16 when he was put on a registry. He went to a dance where you're supposed to be 16, and he met a girl and they dated. They had sex twice, I think, and he found out she was only 14. So he broke it off because she was too young. And about 6 weeks later, she ran away, and the police came pounding on Ricky's door and asked about this young girl. And he told them, I found out she was too young. I broke it off. And he said, oh, that's what she says too, but she was only 13. So he was charged and didn't have to do prison time. This is what kids are told. You won't have to go to jail. You won't have to do any prison. All you do is plead guilty, and then you're on a registry. It's so much better for you. And it's not. They don't know that it's a lifetime sentence when you're a child and put on a registry. How do you go back? You're not even allowed in many of the schools. It's just got too many challenges. One of the other things that I just wanted to mention is it's just a tool of management. It's like one tool in your garage full of tools. Danny Heinrich, the man who took Jacob, was not on a registry. we had about 5 suspects at the very end they couldn't clear. Not one of them would have been on a registry, even if we'd had it back in 1989. So it's just, it may not be the best tool. It's a tool. I think it's a good tool for law enforcement, but it can't be the only thing that we rely on to building community safety. I would like to see more in terms of prevention, where we're teaching people about healthy relationships and sex education. Many times kids especially are getting all their sex education from the internet, and it's often violent, it's often exploitive, and it's not really the behaviors we want them to be doing, but we don't have comprehensive sex ed, we don't have the healthy relationships curriculum in most schools. So who'd be surprised when kids screw up or they model what they've seen on the internet. The other thing that I served on a committee with the National Center to study children with problematic sexual behavior, and pretty much everywhere they're not wanting them to be called juvenile sex offenders. I think that Minnesota's been good about that. But I have a couple of pages of research that we put together for that on the success rate of treatment. They have like a 2 to 3% recidivism rate when handled and given the proper treatment, which is, it's good. That's what we want. One of the things that changed along the way is everybody kept strengthening these things, and the language of predatory offender can be really, really misleading. To me, that word sounds stranger-based, when in fact we know that most of the time, especially with kids, like 90% of the time, it's a family member, a fellow student or neighbor that they're having an inappropriate relationship with. It's not a predator per se. I think that language can be really, really harmful, especially for children. I just wanted to raise some of these things. We no longer live in that world of 1989 when all of this started. We have so much more research on what works to turn these lives around and managing these people so they're not put in situations where they can easily reoffend or anonymously reoffend. So I think that we need to tweak a lot of it and keep asking the questions, how can we turn this around so that this person never reoffends again and becomes a contributing member of society in my vision of what I would like to see. But my biggest concern is children and how we are addressing children. There's a lot of research to show that their behavior and what they do is far different from an adult who's offending. So we know about brain development. It's not fully, that cognizance is not there in the prefrontal cortex till like 25, but yet we're putting the same adult consequences on youth. And that's what I wanted to mostly speak about. But I would like just to have us look at where are we at today. We know a lot that's different than what we knew when we passed these laws. So I think I'm really excited to be part of this and take a deep dive into the 3 subgroups that you've set up. So thank you. I won't take any more time, but just wanted to share it first.
Thank you so much for being so willing to speak this morning as to your perspective and some of the history. And so now we're going to dive into a historical presentation on this. Patty did mention a couple of the points that we're going to be addressing today. Thank you for doing that. So we are starting in 1991. We're going all the way to 2021. And we're going to provide the context that we are aware of and that we know of, with the understanding that over time, the historical context sometimes gets lost. We are sharing those items only that relate to 243.166 and cases. So know that we are purely speaking to the registry, not assessments, not any other items. And we're happy to take questions at the end if folks have them. We can also provide a handout that will show the progression of the statutes over time if that is useful for folks. So just let us know what you would prefer. So Katie, do you want to present from yours, or would you like me to present? I can. Okay. Okay.
Okay. All right, good morning, everyone. Thank you, Patty, for all that good information. And sorry, again, a couple of my slides will reiterate what Patty said, but clearly covering that historical piece of information here. So moving through, as Patty had said, when Jacob was abducted, basically she's covered all of these points on here that law enforcement officials had no way to determine where the predatory offenders were living, sex offenders were living at that time. They had no way of determining which offenders had committed similar crimes in the communities, and had no knowledge of where those individuals were living in their community. I don't know if this is going to work because I can't see my whole slide. Oh, there we go. Okay. The first version of the law came out in 1991. Minnesota began registering sex offenders and registering those adults who were released from prison after August 1st of 1991 who had child victims. And these child victims needed to be victims of kidnapping, certain criminal sexual conduct, solicitation and prostitution of minors, and use of a minor in a sexual performance at that time. The only information the offenders were required to provide was their primary address, and they needed to do so 10 days prior to moving. The statute also required that the registration period run 10 years from their release from imprisonment. And at that time, failure to register was a misdemeanor, but added that 5 years for that period of non-compliance. The statute was modified again then in 1993 to include those offenders who were sentenced to probation, and also added in adult victims. So at this point, we're looking at adult victims with adult-only offenders. This included offenders who were charged with or petitioned for a felony violation or attempt to violate any of the listed statutory provisions and convicted of that offense or an offense arising out of the same set of circumstances. Also at 1993, first-degree murder clause 2, which has a sexual element to it, was added, and the registration period was it started off as at 10 years from release from incarceration, but it added, because of the probationers, 10 years from the assignment of a corrections agent or the duration of their probation, whichever is the longest. Also, it required registration for prisoners from other states, and added predatory crimes to the registration, the offenses requiring registration, and the predatory crimes is under that chapter 09. Then in 1994, juveniles were added to the registry. They also modified failure to register to have it be charged at a gross misdemeanor level instead of a misdemeanor level, still adding that 5 years. It also required registration for those offenders who come to Minnesota on an interstate transfer. For those of you that don't know what that is, a probation transfer. So we have the prisoners back in the old version, and then now added the interstate transfer. So those who are still under supervision in the state of conviction to come and register if they're registered, if their offense requires registration here. Also changed the requirement to the offenders having to change their primary address 5 days prior to moving instead of the 10. It also called out that the period of civil commitment for those offenders who were committed as sexually dangerous sexually psychopathic personalities and sexually dangerous persons, that their 10 years, their period of civil commitment does not include their 10-year registration period does not count towards their civil commitment period. Then in 1995, the sex offender registration law was modified to include comparable federal offenses. Also, out-of-state requirements were modified to apply to all offenders, as opposed to only those released from prison or under supervision when they come here with an out-of-state offense. Sex offender registration law was also changed to begin the day that the registration form is signed. Statute also specified that out-of-state offenders would need to enter and remain in the state for 30 days or longer. Then in 1996, there was a legislative intent that was published, stating that the legislature finds that if members of the public are provided adequate notice and information about a sex offender who has been or is about to be released from custody and who lives or will live in or near their neighborhood, the community can develop constructive plans to prepare themselves and their children for the offender's release. 1997 then added offenders who are released from prison would be assigned a risk level 1, 2, or 3. Information regarding level 3 offenders is made available to the public and also requires notice to the state in which the offender plans to live if that state has registration. This should be that the offender is required to disclose if they're moving to a state where registration would apply to them. In addition, the BCA shall notify local law enforcement if an offender is moving into their jurisdiction. In addition, if the person's leaving the state, the Bureau is required to notify the registration authority in the new state that the offender is moving to. In addition, the verification form process began in 1997 and addressed that failure to comply with that section within 10 days of that section could result in a failure to register. 1998, additional offenses added, such as criminal sexual conduct in the 5th degree, at the felony level, indecent exposure at the felony level, as well as false imprisonment of a minor. It also removed the standard that someone remain in the state for 30 days to require registration, and now stated enters the state for the 30 days. Registration information, it also addressed that information on juveniles and adults may be maintained together. 1999, language added that the courts may not modify an individual's duty to register in the pronounced sentence or disposition order. Added the kidnapping of an adult to the list of crimes requiring registration. Also required registration for civil commitment as a sexually dangerous person or sexually psychopathic personality in another state, or federally or comparable federal commitment as well. Also added a portion on regarding offenders who are committed as mentally ill and dangerous and charged with an enumerated offense and either found not guilty due to this mental illness or deficiency following a trial, or found guilty but mentally ill verdict, and the person was committed as mentally ill and dangerous, would require registration. On May 26th of 1999, Katie Poyer was abducted in Moose Lake, and the kidnapping and murder of Katie brought the then sex offender registration laws into the spotlight to make changes to the registration laws. Katie's law took effect in 2000, changed the sex offender registration to a predatory offender registration, added court-martial and military offenses with out-of-state and federal offenses, added the requirement of those working and attending school in Minnesota to be required to register, increased the penalties for violations of registration requirements to a felony, and increased the number of offenses that required registration. In addition, added the following pieces of information that the offenders were required to provide, to include any property they own, lease, or rent, as well as reporting their address for their work, school, and then vehicle to include year, make, model, plate, and color. Added lifetime registration for some offenses for both juveniles and adults. Added that incarceration for any new conviction of a registration offense or revocation for the registration offense would restart their registration period if it involved a conviction. Required 16 years and older may have their information made available to the public due to their lack of compliance if they are non-compliant for 30 days or longer. And changed failure to register to a felony level crime. sorry, I'm pretty sure I said that on the slide before. It also added another statute with the 243.166. It added 243.167. What this did is added 2 ways for offenders to come onto the registry, different than what was called out in 243.166. The first way is any offender, regardless of the state of original conviction, must register in Minnesota if they have a past conviction that is comparable to a Minnesota registrable offense and did not have to register at the time and is convicted of a crime against the person. And that applies to crimes committed on or after August 1st of 2000. In addition, any offender, again, regardless of the state of the original conviction, must register again if they have completed their initial registration period in Minnesota or the other state and are subsequently convicted of a new crime against the person as defined in 243.167. In 2001, it provided the Bureau to inactivate offenders who are no longer living, working, or attending school in Minnesota via the verification process. Also modified offenses in which juveniles were previously required to register for life. It added the specification that the only first-time registrable offense for juveniles needed to be a conviction for first-degree murder, clause 2, again with that sexual element involved in the murder. Then on November 22nd, 2003, Drew Shadeen was abducted from the mall in Grand Forks, North Dakota, and was killed. And the kidnapping of Drew brought the spotlight back to the registration, community notification, and civil commitment issues in Minnesota. 2004 to 2005 legislative activity. As a result, the 2004 and 2005 legislative sessions included numerous hearings regarding sex offender registration issues. And the following changes were made to 243.166 and 243.167. Previously, the statute required registration for felony charges or attempted charges. The law now added to include aiding and abetting and conspiracy to commit offenses as well. And it added criminal sexual predatory conduct and false imprisonment of an adult or the minor still under 243.166, and added 4th degree assault to the list of crimes under 243.167. Added a provision for homeless offenders, so that homeless offenders who lack a primary address, what we would call a homeless offender here, must register with local law enforcement agencies within 24 hours of no longer having a primary address, and then are required to report to law enforcement, the law enforcement agency in the jurisdiction where they're at on a weekly basis between 9 and 5. And that the verification letter will be mailed to the law enforcement agency from the Bureau for those offenders, and that's effective June 3rd of 2005. In addition, a change was made to include not only a conviction for a new registration offense or the revocation for the registration offense, but also now any new conviction for any offense or revocation for any offense will restart the registration period if they are convicted or adjudicated. Also, it called out out-of-state offenders who visit or vacation in Minnesota for 14 days or longer are required to register. Information from 2008 to 2012, the legislature called out that it was sufficient notice for the Bureau to mail the verification forms by first-class mail. And again, these forms are either mailed to the offender's primary address by statute or to the local law enforcement agency if they are homeless by statute. Also, if an individual previously was inactivated, who returns to Minnesota to live and their registration period has not expired, they must check in with the local law enforcement again and continue their registration period until that expires. Also modified the list of offenses that require registration, as well as adding access to human services to be allowed access to the POR information for the purposes of conducting background studies. From 2014 to 2016, the effective language was for crimes committed on or after August 1st of 2014. Registry added a piece of information requiring that the same set of circumstances language apply to out-of-state and federal offenses as well as those in Minnesota. Added that law enforcement can obtain new photos during compliance checks, and those compliance checks can be done at the frequency of law enforcement's choice, as well as that registration periods will restart for offenders who are given credit for time served. Prior to that, it was for time served subsequent to the conviction. Also added modified offenses requiring registration, as well as law enforcement requested the ability to share or confirm the POR status with a child protection worker to be able to complete family assessment. The 2019 legislative session made the following changes to 243.166. Under the information that subdivision 4A, Prin A required offenders to now provide phone numbers and vehicle tab expiration year, as well as a change to subdivision 7B, which is the use of data, that the corrections agents may also disclose the status of an individual as a predatory offender to comply with section 244.052, which is again that family assessment. The 2021 legislative changes just simply made this change. I believe this is one of my last slides, and I'm going to let Angie attest to this one because I think she could probably, if there are questions about this just simply remove the offenses and added an offense or involving similar offenses to an offense. Again, Angie can speak to that. I'm assuming she is on and will help me out with that one.
Did you want me to speak to that now?
Or, oh, she's not unmuted.
Oh, that's okay. She's trying to, is Angie, can somebody unmute Angie? Can we go back to that slide? Angie, do you want to speak to that? Kendra, can you unmute Angie?
Hello?
Okay.
Can you
Okay.
hear me?
Oh, yeah.
Okay. Yeah, this was just added. My understanding is to clarify, to try to make it uniform. And I talked about this a little bit at our first meeting, to try to make the application of out-of-state offenders uniform with, so if somebody would have to register for an offense in Minnesota, they would have to register for the same type of offense if they came in from another state. And it came out of the Martin case, right, Katie? That was the case, right?
Yes.
It came out of the Martin case, and what had happened is the language of that case was very specific as to that the out-of-state, the elements of the out-of-state offense had to exactly match ours, which hardly ever would happen even on a criminal sexual conduct case, because we have like very specific age requirements for very specific, for each specific provision or different provisions. So even with kind of run-of-the-mill secondary criminal sexual conduct, if another state statute was just a little bit different in the wording or the element, somebody who would normally be required to register here wouldn't have to because of that. So this language was an attempt to make it consistent with out-of-state offenders and Minnesota offenders, if that makes sense.
Thank you, Angie. And my next slide then is if there's any questions, or we can wait and do questions at the end with Angie just as well.
Doesn't matter to me. Okay,
Angie,
so
did you want me to flip through this for you, or would you like to?
sure,
Okay.
that's fine. Let me, just from an introductory standpoint on the cases, what I did and Olivia did is we went through the cases on there generally tend to be constitutional cases that talk about the purpose of the statute because they get into the purpose of the statute with respect to whether it's a civil regulatory statute versus a punitive statute. And also like when they do the ex post facto analyses. So those are the kind of cases generally that have any language that talk about the purposes of the statute. But because one of our charges is to look at, the effectiveness of the statute to achieve its purpose, we just wanted to summarize at least what the courts have said about what the purpose of the statute is. You can go, okay. Spalton versus LaFleur, we have talked about, I think, before too. I think I talked about that in my initial presentation. And that was it was a case that both challenged the constitutionality of the statute and also had some same set of circumstances issues within it. But that statute talked about that the primary purpose of the statute is to create an offender registry to assist law enforcement with investigations. And then it ultimately held it was rationally related to the legitimate state interest of solving crimes as far as the constitutional part of it went. Go ahead. Then Kaiser versus State, and I also tried to put these, I think we did put these chronologically just so you can kind of see what the courts have, said over the years in kind of a chronological sense. So Kaiser elaborated a little bit on the primary purpose, and they said that the statute's an expression of the policy statement that society has the right to know a predatory offender's presence, not in order to punish them, but in order to protect itself. And then it said that the law seeks to increase public safety by requiring a specific class of offenders to provide information to law enforcement authorities to assist in keeping track of them. And then Gunderson versus Voss. So this is, so it's Eighth Circuit. So this is persuasive authority in Minnesota cases, but if there's a constitutional challenge on the federal level, then this is precedential on the federal level. And they said that the Minnesota legislature was attempting to ensure the inclusion in the registration rolls of all predatory offenders, including those who take advantage of favorable plea agreements. And Gunderson versus Voss was a same set of circumstances case, not only on the plain language of the same set of circumstances, but in the Gunderson versus Voss case, it was actually a situation where he had been charged with a registration offense, and there had been an attempt to keep him off the registry by recharging it in a separate complaint, recharging the same set of circumstances offense. And the court found that it was still part of the same set of circumstances, and then put this language in that the legislature with that same set of circumstances language was trying to include those who took advantage of favorable plea agreements. The court acknowledged the statute may lead to unfair results in some cases, but found that the legislature had intended that those people register where there was a conviction out of the same set of circumstances. And then the concurrence stated that, and I think this was a one-judge concurrence, but anyway, he clearly was not a fan of the same set of circumstances language. And he said that the Bolton case turned, and the statute turned reason and fairness on its head. But concurred in the opinion because he said there was no constitutional violation. Go ahead. And then we have State versus Jones, and State versus Jones was actually looking at the civil regulatory criminal prohibitory from a public law 280 standpoint. It was a issue with respect to a Native American registrant. But they did look at the purpose of the statute, and they said that the fact that the legislature established a predatory offender registration system was an indication that the whereabouts of predatory offenders, in comparison to the whereabouts of the general population, presents a substantially different or heightened public policy concern. So interestingly, they didn't compare them to other types of offenders. They compared them to the whereabouts of the general population. And then they also said that a review of the legislative history indicated that the public policy concerns associated with persons convicted of specific predatory crimes had grown over time. And State versus Lopez, I think I mentioned in my initial presentation also, that one talked about the purpose of the same set of circumstances language, and the requirement was meant to ensure that true predatory offenders cannot plead out of the registration requirements. And they added the language and said that while the threshold showing a probable cause necessary to support a charge was low, the language requiring a conviction for the same set of circumstances limited the number of people who might be forced to register. And LaFountain is actually a Court of Appeals decision, and the only reason we mostly just left Supreme Court and the Eighth Circuit and US Supreme Court decisions in here. But I put LaFountain in because that was the only published decision that kind of talked about the database more. And they did a little bit of a history in that case, just in general. They went over kind of a thorough history, but they said the predatory offender registration statutes generally serve two purposes. First, a continually updated database of information on convicted predatory offenders improves law enforcement's ability to supervise offenders and investigate new offenses. And then second, community notification allows members of the public to protect themselves from risks in the community. And the second part obviously goes to the community notification statute, but I wanted to leave them both in there because they were kind of together in that analysis. And then Connecticut versus Doe is one of two United States Supreme Courts that have addressed the constitutionality of registration statutes. In Connecticut versus Doe, that's a internet-based statute, which we do not have. That's a situation where anyone who has a conviction and is required to register is automatically in a publicly accessible database, which is not true in Minnesota, except for those out of compliance or in the level 3 offenders, which is a separate statute. But in Connecticut versus Doe, they have more of that language that I think has been talked about, you know, with the threat and the recidivism. They more talk about that there. So obviously they're dealing with the Connecticut statute, but in the opinion, they talk about sex offenders being a serious threat. Victims of sex assault are most often juveniles, and when offenders are convicted and re-enter society, they are much more likely than any type of offender to be rearrested for a new rape or sexual assault. And that's some of the stuff that is, I think, disputed, depending on who you talk with. I know that the recidivism rates have gone down, and depending on what you look at, you know, that may or may not be so true anymore. And then Connecticut, like every other state, responded by enacting a statute designed to protect its communities from sex offenders and to help apprehend repeat sex offenders. So again, this is a United States Supreme Court case, so it doesn't say the purpose of our statute, but it kind of talks about the purpose of sex offender registry statutes in general. And Smith versus Doe, similarly, that was dealing with Alaska's predatory offender registration statute. And again, that's one that was a public statute, internet-based registry, sorry. There they said sex offenders pose a high risk of reoffending, and that the statute goes to protecting the public from sex offenders. Release of certain information about sex offenders to public agencies and the public will protect the public safety. And then they said they're designed to prevent repeat sex offenses and aid in the investigation to report offenses. And I think that's the last one we had that we found that talked about the purpose of the statute.
Yep, and so thank you, Angie, thank you. And so now we can start with questions if anybody has them on this presentation. We had initially scheduled the presentation for 45 minutes, so we have quite a bit of time here, about 12 minutes left to chat through this. Senator Ingebrigtsen.
Well, thank you. Thank you to the presenters. Can you hear me?
Yes.
Yep.
Yeah, okay, good. I have a couple of questions. And these might be real, I don't know, foolish. Far be it for me to ask a foolish question, but there's been a lot that's gone on since the day of Jacob's abduction when I was a young rookie working on the road and as a law enforcement officer. And One question I have is there anything in statute with regards to the protected class? What I mean by that now is transgender, things like that. Are they protected at all under these registrations? And my second question would be, I bring that question to the forefront because actually when I was sheriff, I had that actually occur in my county. And my second question is, any court rulings that have ruled that level 3 notifications are too punitive? Has there been any talk of that?
So I can speak, I think, to the court rulings. I'm not aware of anything that has specifically held that. I mean, that statute has not been, it's been found to be constitutional to the extent it's been challenged. And I'm not sure what you mean about the protected class. I don't know of anything that specifically addresses a protected class in the statute itself. I don't know if Katie knows of anything, but I'm not sure when you say that protects, though, like what kind of language are you talking about?
Okay.
Because I think it.
Well, I'll go right to it. Thanks. And I don't know what year this was, but a level 3 sex offender, male sex offender, came to my county. We did the full-blown notification, and he became somewhat of a problem in the community going around. Folks knew who he was, which, you know, it was actually working fine. There wasn't anything terribly wrong going on. However, he came into to my office at that time and declared himself a female, and that would that would put him under at that time the protected class. Now maybe that's not even.
Whoops. Bill's muted.
Senator Ingebrigtsen, it looks like you got muted there for a second.
Oh goodness, I don't know
Okay.
where.
So
Yeah.
I think I cut off when you said that he had come into your office and declared himself.
He come into my office declaring himself a female, and that at that time would be under, you know, he would be classified under a protected class, which would limit our ability to monitor his registration. You know, if he has a full beard or he cuts it off, things like that. At that time, we had we had an opportunity to notify the public on those very drastic changes. But do you recall anything like that at all, or if that were to happen, what if someone were to be charged as a male and for some reason they decided that they were going to do this transgender thing with themselves personally, would that make a difference at all, or is there such a thing? Is there any such a thing as a protected class, I guess?
So
It shouldn't make any difference under the statute because the statute would be based on his conviction. So while he changed, I would think, you know, the BCA would get information if there was like a change of his name or her name. The BCA law enforcement would still have the ability to take photos. So if her appearance changed, so I don't think that would really impact whether she had to register. I think it would impact the information that the BCA would need and that law enforcement would have to track that, if that makes sense.
Yeah.
Katie, is that accurate? Oh, Katie's muted.
And
can we unmute
Yeah,
Katie?
they just. Yeah, that's my understanding too, Angie, that as long as the conviction's there, it has no change based on the transgender.
And I don't think this happens very often, but it happened to me, and it really caught me off guard at that time as an administrator. But the second question was talk about punitive. Any court rulings on level 3 as being too punitive here in Minnesota that you recall?
Yeah, and that's, to the extent that statute's been challenged, it has not been found to be unconstitutionally punitive.
Okay, good, thanks. Thank you very much.
I believe Representative O'Neill was up next.
Or
Thank you. I think Nate was ahead of me, but
I'm sorry.
he's okay. You want me to go, Nate? Okay, so my question has to do with kind of the collateral damage and consequences of being on the registry. For example, when background checks are done and that is flagged. And I'm wondering if there's any court opinions or rulings regarding the collateral consequences of being on the registry when it comes to when background checks are done. So they're, you know, in some places in Minnesota, certain offenders are not even allowed to live in certain communities and so on. So we've got issues of where they can live, where they can't, where they can work, where they can't. And I'm wondering if there's been any court opinions about the collateral damage consequences for being on the registry as a whole, for those specific reasons when you're doing background checks.
Well, so somewhat. I mean, the rulings have more encompassed that as part of, you know, employment issues or issues with finding housing. There are a couple of published opinions that came out a couple of years ago, Thibodeaux, Thibodeaux, and Bedeau, Bedeau. Those both addressed, they challenged the constitutionality of the statute kind of under the theory that now there are so many more requirements than there were at the time of Boughton. And including, at least in one of them, I think they talked about the ordinances in the communities, maybe in both of them. And both of them, the court found the statute still constitutional with those consequences. But if you look at the actual opinions themselves too, I mean, some of the issues they raised were premature, or they didn't really have standing to raise them because they hadn't applied to them those consequences. There's also a recent Minnesota Supreme Court decision, Werlich, Werlich, and that also addressed some collateral consequences. Again, not necessarily specifically the background, but it got into some of those issues. And the only one that so this was on a motion to dismiss, so that was remanded on the one issue of the statute. I think it's 626, it's a human services statute. The human services statute that says somebody automatically is investigated for termination of parental rights if they are a predatory offender, that they have to be referred for that investigation. That was remanded, but that case now on remand, my understanding is it's going to be dismissed because he does not have a relationship with the child. So those are the cases that, at least the recent cases I can think of, that have talked about kind of those collateral consequences. Does that answer your question?
Yes, thank you. I think it's just a conversation that we do have at the legislature quite a bit and probably should be discussed here too, since we don't really have.
Well, and
we have a kind of an off ramp, but go ahead.
One of the subgroups is addressing collateral consequences. So that might be one that you, if you're not on it, you might want to be on it.
Representative O'Neill is on all of them.
All right, yay. So we will be addressing that.
Thank you. I think it's an important conversation. Yeah, I will be in all the small subgroup meetings so that I can be fully informed when I bring the language changes back to the legislature, and I want to hear all the concerns and how the recommendations are drafted. It's really important. In fact, I think today is a good celebratory day because today the statutory changes for sexual criminal conduct statute goes into effect, and so today is a great celebratory day. And the work of that subgroup or those subgroups really impacted state law. So I'm really looking forward to how this is impacted.
Nate, you are up.
Thank you. Actually, I have a question about more direct consequences, which has to do with the penalties of violating predatory offender registration. I was curious about when you were talking about the 2000 changes that made it from a, ramped it up from a gross misdemeanor to a felony. It also sort of went a step farther and made it a mandatory minimum year and a day in prison for violating that. I'm wondering, was there some kind of history in at that time where not only there was sort of this legislative finding that it's necessary to capture all these people on a registry, but that there was also a big problem with people violating that requirement and not going on the registry when they're supposed to go on the registry, and therefore it was really important to put these pretty severe consequences for failure to register. And I'm just wondering, what, like in any of these stories, like with the Katie Poyer case around that time, was there something that happened where somebody was not on the registry who should have been on the registry and therefore something bad happened? Just curious what the legislative history was for the mandatory minimum.
So the mandatory minimum did come out of Katie's law. So it did come from the Katie Poirier case as far as we were aware in doing our research. There was significant buy-in and a number of statements made by county attorneys as well at the time as to their concerns. But again, our knowledge of the history is limited by what legislative history is available to us. And so those are the things that we're aware of. There are likely a number of other narratives that we just don't know any longer. But if anybody has additional context, we would be very interested in hearing about it.
Well, and I would note too that the federal requirements require a felony level sentence. So I don't think that's why I originally got into ours, because I think those federal requirements came after we had it in our statute, but I think they currently require a felony. That's my understanding anyway.
And I've mentioned this before, but back at that time, there was a frustration from both law enforcement and prosecutors with the amount of work that went into a case for failure to register, and that as a misdemeanor, whether misdemeanor or gross misdemeanor, it didn't have the strength that they needed in order to put all that work into prosecution.
So in order for time's sake and to move forward with the agenda, I'm just going to take one last question. Again, folks, feel free to email them to the entire group and we can respond to the entire group as well, just in case there's overlap in people's questions or concerns. Jerry, I believe you were the next one with your hand up. Can we unmute Sherry, please?
Yep.
Oh, sorry. Good morning. Quick question as I listened to this and I looked at the information that you provided on homelessness, and one of the questions that I wasn't clear on is GPS monitoring and the notion of any statutory understanding as to when, how long, why not, if it is removed, or if that becomes a consideration more broadly as we think about the ability to keep track, which I think was raised at the onset of last call, or as you look at some of the homeless or address agnostic challenges that law enforcement faces. More of an education for me initially, but also statutorily a consideration, I think, as for subgroup 1, maybe around registrant requirements, that I was wondering if you could provide more insight on.
The statute doesn't have any connection to or any kind of GPS requirements under 243-166. those requirements generally come only under like the Department of Corrections Supervision Authority or Probation Supervision Authority. So that's a whole kind of separate area as far as GPS. I wouldn't think that would be something that we would want to have in the registration statute.
Okay. Again, please feel free to send questions to the group. We're happy to respond as best we can to any and all questions that we receive. Sheriff Hack, you are up to discuss data requests. Sheriff.
Thank you. So wanted to touch briefly on data requests. We've gotten a number of data requests, and I think all the chairs are very pleased to see that there are a number of people that want to delve into the data and find out the data-driven answers to these questions that we've been posed. So having the objective data that shows what has actually been going on is, I think, the goal of everyone here. That's the good news. And again, the good news that I think from my perspective is that there are so many people committed to finding that. The bad news I have for you is that I don't know that we're going to get a lot of good objective data. After having conversations between the co-chairs and the state folks in the work group, it does not appear that there is a lot of the types of data that we're looking for readily available, simply because the systems that are built around this predatory offender registry are not built to be a system that tracks and spits out data. It's built simply to be a way to track people and the things that are statutorily required to track. So I think we're going to run into some issues as far as finding the objective data that we want. I think that in our conversation as co-chairs, we don't think that that puts an end to the work here by any means, but I think that we need to make sure that we're aware of the fact that as we go forward, there's gonna be a lack of good objective data, and that as we reach out to try to find things that we can point to as talking points and as things to consider, that much of that may be anecdotal data. So in my opinion, I think we need to be cognizant of that when we hear people talk about things they're seeing and their perspectives, that much of that may be anecdotal data, and that we need to, again, in my humble opinion, be cautious about what exactly we're basing our recommendations on. I will allow our friends at the state courts and at the POR registration to talk more in depth about what data they have and what data they don't have. So people that want to make further data requests can kind of take that into consideration as we move forward. And one other thing I would like to talk on briefly is the data requests that we've been getting. And again, it's great that we want to find this data, because I think that's going to provide us with a lot of answers. I do think we also need to be cognizant of the fact that there is a limited amount of resources that the folks from the state that are in this work group can bring to researching and fulfilling these data requests. So if we're going to have data requests going forward coming from this work group or coming from some of the subgroups that are formed, I would ask that those data requests go through the leadership of either the co-chairs or through the chair of the subgroup, so that we can kind of come together as a group and talk about what is important, what data we want to request. Because again, we can't have 15 different data requests. That just isn't going to be feasible. And even, you knock that number down even to like 5 large data requests, that it's going to be very difficult for us to get through, and for the folks at the state to attend to, and also attend to all the other work that we're going to be asking them to do. So for future data requests, again, if you would work with the leadership, either the co-chairs in the large group or the chair of the subgroup that you're on, to make sure that we're coordinating that, and that we're really asking those folks that have to search through this data to find the data that is really going to inform our conversations. And with that, I'll yield to either of the folks from the state that want to talk about what data is actually available.
So BCA is just going to be really quick about this. Just a brief background, part of the discussion that we just had and part of the history is that the system was purely built to figure out where somebody is right now. It wasn't built to compile statistics. It wasn't built to pull criminal histories, those kinds of things. And it has changed over time. But we do just want to say that when we're pulling data from the POR registry, it is going to be primarily based on location and overall statistics as to numbers or gender, for example, because the database simply wasn't built to pull for anything but that. It was intended purely as a law enforcement tool when it was first created, to be able to track and find individuals in the area for purposes of investigation. So just know that we'll be responding to data requests with what we have and what we don't have, but beyond location, age, gender is going to be very difficult and will require manual labor. So it is of upwards of 18,000 files. So please know that there are some things that we may not have time to pull because of that. So just know that that's a little bit of background from the BCA's end. Karen from the courts, would you mind speaking to what the courts has available? Can we unmute Karen, please?
Can you hear me now? Fabulous. I think I see nodding. Okay. So I've just got 6 or 7 talking points. Olivia, if I miss anything, please prompt me. But in essence, MNCIS is a court case management system. So the court also does not have any data to indicate that either a defendant is a registered offender or is required to register. I think, as was noted during the last meeting, the question of whether some defendants are required to register is often a puzzle. I think that the AG and the BCA solve after a conviction. And so that is not a conversation the court is part of, and that's not data that the court tracks. The court can certainly provide case filing and conviction data, and we can do that on the registration offenses, the 243-166. We can also do it on any other offense that you might find relevant to this analysis, whether that's criminal sexual conduct, charges and convictions, kidnapping, anything like that. We tend to try to rely just on case counts, which is slightly different. A lot of the questions we've seen are worded in terms of person. How many defendants, how many registrants? And while MNCIS at its core was built to track persons, and we do have a party record, the party record matching is an imperfect process. Any slight misspelling on different criminal complaints, the use of an alias, can result in one human having multiple party records in our system. So if we were going to do anything more sophisticated, like a person study or a recidivism study, that's actually kind of that's a miniature project that would require much more time and dedicated staff. So I think that's the high points, and I have already asked our research staff to pull the type of data they can readily produce. I was just looking at the first set this morning, and it's just a snapshot of the data under the 243-166. I think it was sub 5A. And so assuming I think that all looks accurate and great, and if anyone is still interested, we can certainly start circulating some reports like that. So I'm happy to work with our research team to produce what we can, but again, those are the limits. We don't track registrants, and we really have a hard time matching people. But case counts, conviction counts, average sentences, things like that, we can pretty easily do. Any questions about court data? Not that I can see any hands from my view, but
I'm not seeing any hands. But we just wanted to provide a brief overview as to that. Because we know that we've received a number of requests. We're always happy to field the request and figure out what we can and cannot pull. Just know that we might not have your favorite answers. And so we will do the very best that we can. We may also need to tell you that it's simply not feasible in the time frame. So just know that we will do everything we can do to pull what we have available. And Representative Moeller?
Thanks. Yeah, I can, as someone as a prosecutor, I've worked in various systems, and so I can definitely understand the challenges in trying to pull this data together, but just wanted to point out that that is actually a recommendation that could be made to the legislature too, is to be able to capture more data, and then of course there would be a fiscal note and provide funding so that whoever's doing that has the adequate funding to track and provide that data. So just want to point that out, that we can make that recommendation as a group if we think that's important.
Okay, on to the next item. Thank you everybody for all of your wonderful questions and points. Next topic was the subgroup topics and goals. And we have some time allotted until about 10:35 for this. We wanted to just briefly dive into any questions that folks may have about the subgroup topics. These were all selected based upon what the legislature passed, with the understanding that effectiveness would be a topic that kind of interwove with things as well. Angie or Sheriff Heck, did you have more commentary as to these subgroup topics or goals?
I guess unless people have questions, we have, you sent the descriptions out to the whole group, correct? When we asked them. So unless people have questions, I think it's fair, I mean, the summaries explain what the different groups would address. Does anyone have questions as far as the scope of those groups? I know we talked about we need to kind of focus on the registration, but the one group will focus on the collateral consequences of registration under other statutes.
Sheriff Heck, did you have anything you wanted to add?
I don't.
Okay.
Thank you.
Did anyone have any questions on these?
Can I just say one other thing, just as far as the purpose of the statute that we talked about? I think we talked about, the co-chairs talked about that we'll address that, or the group should address that kind of as a whole group versus in the subgroups. But I certainly think if there's something in the subgroup in particular that comes up that you think, goes to the effectiveness of the overall statute, that is something you can bring back to the whole group. But as far as the overall kind of legislative report or recommendation, we thought that would be better kind of combining the subgroups as far as the meeting that intent, if that makes sense.
Any other questions, concerns? We're cruising today, guys. We are just moving like the wind. Okay. Effectiveness and its role in discussions. As I briefly mentioned earlier, effectiveness is something that we wanted to provide a solid background on as to what the registry was, and therefore what the goals initially were. Obviously, time has changed and the rules and laws around it have changed, but we also wanted to be sure that each one of the subgroups was bringing back any discussions on effectiveness to the large group, because there may very well be overlap amongst these effectiveness conversations, and it is likely interwoven with a number of other things. Angie or Sheriff Heck, I'm not sure if you both had commentary on this. Those were all the notes that I had from the chair's conversation about it.
Yeah, and I think that's what I just talked about too. So I think that kind of covers that.
Look at us moving. We're just so fast. All right. Well, it looks like we are moving at the speed of light here, and so we may finish early. just a couple of friendly reminders before we open up to public comment. So please be prepared to, on your first subgroup meetings, to appoint chairs. Know that that chair is going to be doing the presentations on some of the discussions to the large group every other week or when the large groups are scheduled. Please sign up for subgroups as well. As I said earlier, we will be you should have already received some calendar invites for these. If we do not hear from you, you will get all of them. Please let us know what you would prefer to be involved in. There are a number of folks who have signed up to be in all work groups at their availability, so know that you can do that as well. I know that everybody's schedules are busy, please know that you can hop in and out of subgroups as you are able to. And now, unless Mark has anything else noted on the agenda, we can open up to public comment. But Mark, correct me if I've hopped ahead on the agenda or if there was anything else you had.
Yeah, just a notice about those subgroups. Those invitations will be on our webpage. So even if you're not on one of those work groups, you can join and observe, or if you're a member of the working group, participate if you become a formal member later. But those are always available on our webpage, and that will be updated as we go along. So all of this information will be there.
Thank you so much, Mark. That's great. And there will also be recordings updated. So if, for example, you're not able to attend a meeting, but you would like to know what the discussion was, those recordings will also be available to folks. So Mark, take the reins, public comment.
Okay. So at this point, we are opening up for any public comment. As we announced earlier, please don't engage with the chat or ask to be recognized early, but this is the time where if you go down to the reactions tab, please raise your hand and you will get listed in order for public comment. So is anybody wishing from the public to make any comments at this time? Raise your hand. We'll keep this open. I am not seeing anybody. Just want to make sure that, oh, here we have Tanya.
Hi, everyone. I apologize. I missed the beginning part of the meeting. I had another work meeting, but I just wanted to, and I've expressed my concerns and my thoughts directly to a few people on the working group. And I just want to make sure that, again, I missed the beginning, so I don't know if this was covered, but that we have actual people, I know that there's this working group, it gets to be very, a lot of people, a lot of voices, a lot of seats that need to be here, but I still don't see anybody that's directly impacted by being on the registry. And I appreciate that we're going to try to make time, that you plan to make time to hear those stories, but I really want to, just my concern and my disappointment that no one's sitting on the working group with a vote and with that power behind it. If people know me, you know that I've been advocate for people that are directly impacted to have power in these situations, not just come in and tell stories, but actually be able to push new policies forward. And so I do want to appreciate and just say thank you to Kelly and to Mark for reaching out to me about my concerns. And yeah, I just want to just bring that up one more time and then move forward. But I really hope that we're able to do things and make some changes here that actually help the community, keep it safer, and we can look at the harms that are being done because of this registry, the way that it stands.
Okay. Was there any other comment or any responses? Okay. Thank you, Tanya, for testing that system, making sure that you are able to do that. But I do not see any other requests for recognition.
So just know, as always, that Mark and I are available via email, and our phone numbers are also online. If folks have comments and they don't feel comfortable sharing them at this point, please feel free to reach out. Those comments will be shared with folks. This is not just an email inbox that things are being sent to. It is Mark and I. So I'm seeing Patty Wetterling and then Senator Ingebrigtsen.
I just wanted to thank Tanya and acknowledge some, excuse me. One of the studies that I have, and I'll share this source, especially when it comes to young people, one survey study showed that as many as 70 to 70% of sexual assaults and abuse that they kids suffered while they were under the age of 18, were committed by other children and other teens. But the law enforcement data is about 35%, because so often these cases are not reported. And one of the big reasons they don't want to report is because the offender, who's probably somebody they know, might end up on a registry. So it's a huge side effect that we're not always capturing. And I appreciate her stating the need to have those affected by, because when it is a youth offended by another youth, neither gets help. The victim doesn't get help, because if they go to counseling, there's mandatory reporting, and the child who caused the harm doesn't get help. And even when it is charged, the child who caused the harm doesn't get support because he's the perpetrator, so it doesn't qualify for victim funding for treatment and all of that. So it's a really complicated factor when it comes to youth. And I just appreciate her bringing that up. The impact is huge.
Okay. Senator Ingebrigtsen.
Thank you, and I agree with Patty and Tanya as well. I'm wondering if this group is going to hear any testimony, maybe that's the right word, from people who have actually been in the system and are in the system and feel that they've been either wronged or those kinds of things can actually help us move forward. But I would take them as advisory only. I certainly would not want them to be able to vote. I have a little problem with that, but advisory only. I think we should be, anytime we can get somebody like that to come in and testify, I would certainly be open to that. I would hope the group would be as well, but I do agree. I think that especially in the juvenile area, the kids are not reporting, and that's really unfortunate, but thank you.
So just a little bit of background, we have struggled because the offender data is private data. How we identify and find an individual who is willing to self-attest and who is willing to participate is a challenge, at least from the BCA's perspective, because we can't pull that for this purpose. So just know that we are open to whatever folks would like to do in terms of having speakers. We are struggling with how we identify individuals from the BCA's perspective. But so just know that that is some of the background from our end of the shop, is that we can't pull the data for that. But
And from the DOC perspective, there have been registrant groups and those who have requested access and the ability, and we definitely agree that those voices need to be heard. So.
Okay, Representative Moeller. I believe you were up, and I know that you put your hand down. Let me know if you want to move.
Well, yeah, I did. So I was going to say that, it was actually my oversight when I drafted this bill that we didn't include somebody who's subject to registration as a member. I actually, had that been brought to my attention, would have drafted that into the language. Although then when I heard Senator Ingebrigtsen talking, maybe he would have wanted to remove that from the language. I'm certainly open to having, one person who's subject to registration being a member of this committee. I mean, I think at the very, very least, we need to hear from folks who are subject to registration, but I'm certainly open to including them as a member of the working group. But I put my hand down because he said something opposite. I didn't want to cause a big, conflict here, but just wanted to make that point.
Then Tanya again.
Yeah, I just wanted to say if there's, I did email you, Mark, earlier this morning about if you need help to find people who are willing to speak on this that are or have been on the registry, please reach out to me. I know quite a few people who are eager to talk about their stories in what it's meant to their life. And I just, again, want to say, and I'm not trying to start anything either, but directly impacted people do deserve a vote. Right, that because they're on the PRO doesn't mean that they are not worthy of having a voice on what it's been doing to, like what it's done to them. I know that the old way of thinking is that, that they've done something and that they're going to come on and many people aren't even on the, they're not there for sex offenses. There's many other offenses. So I just, again, push again that we give space and power to people who are directly impacted, not just to hear stories, but actually move things forward. Thank you.
Okay, Sherry.
Tanya, I just want to thank you as well for that commentary, and Patty as well. I think the thing that confuses me most about our role and what we're advocating for is the root cause and the support and the help that people need. And that's where I'm challenged. Patty, you spoke of children to children, but the same resistance is when it's a parent to a child in the home, because you are aware of that role in your house and putting your parent on the registry versus getting help. And that challenge is, I think, the challenge that many experience one way or the other. And so I can appreciate where we sit in terms of the statutes, but I also, what some of the data that interests me most, which Mark, I think is probably the hardest to get, is of people who are on the registry, how many are victims? And that's the part for me that I get so torn about this work in its entirety, because at the onset, and I say this to the group, my child is that. And my help that I've given her is ongoing every day, constantly, always, so that she doesn't become an offender. And I say this with a tremendous, pain, because it isn't what any of us wants. So at the core of it, that Tanya and Patty, your challenges are the ones that I'm not sure where you draw the line on advocation and therapy and resources, which is not necessarily what this is for. But how do we be better than this registry is allowing us to be?
Representative O'Neill?
Thank you. So when we were in the statute reform working group and this topic came up, I believe it came from those that were public defenders or defense attorneys. And I'm wondering if they are still a part of this working group, because it seems like they were some of the loudest voices that this needed to be reformed. And in a sense, they do represent those that are on the list or potentially could be on the list. So I would point out that I believe they're still a part of this working group here. Yep. And so they have an interesting collective voice and obviously have to navigate the ramifications legally for their clients. So I would just point that out too.
Senator Ingebrigtsen.
Thank you. And yes, I do bring the old the old theory of thinking here to the group, and I hope it's somewhat valuable. But I still think that having that testimony from those that are willing to do that, there has to be a way that we can make it so we don't have to. We can assure that the person is involved or is a registrant. However, it can be kept confidential. They do it on TV every night. They screen out somebody's face. So I don't know if you're going to get into that kind of testimony or not, but I think some of that can be very valuable. Thank you.
Okay. Since we still have time, any other comments? If not, we can wrap up this session today. We want to thank you all for participating. Again, if you want to submit any information, any details, send that by email to both Olivia and I. Again, the webpage is the best place to find all the information that we have noted. The recording of today's meeting will be on there within the next couple days. And any of the documents, any of the presentations will also be listed by date. So you can go to that. Anything else before we adjourn this meeting today? So next subgroup meeting will be this coming Monday at 9 o'clock.
Okay. Have a good day, everyone.
Okay.